Here I'm going to look fairly briefly at data protection and legal proceedings. There's been a recent Court of Appeal decision, a case called Johnson v Secretary of State of the Home Department, and it's a very helpful decision in that it goes through the law in the Data Protection Act of 2018 and the General Data Protection Regulations. And the key is that for all intents and purposes, data protection laws do not apply to legal proceedings. There were five issues in this case which involved a person who had been deported to Jamaica appealing against that order, and the hearing was conducted remotely, so the appellant was in Jamaica. What that meant was that data was sent by the Home Office in the United Kingdom to the British High Commission in Jamaica so that the legal proceedings could be dealt with. So they were partly being dealt with in Jamaica, but actually being heard in the United Kingdom. That happens anyway and is not due to COVID-19, but clearly with COVID-19 and the way remote hearings have been conducted, this is likely to become much more of an issue in the future, as there will be more remote hearings being conducted from outside the United Kingdom. But the first issue was whether the appellant, that's the person who had been deported, could object to the processing of his sensitive data. There is an exception in Article 21 of the General Data Protection Regulations that the data subject has the right to object, and the controller shall no longer process the data, but the exception is unless the controller, here the Home Office, demonstrates compelling legitimate grounds for the processing which overrides the interest, rights and freedoms of the data subject, or for the establishment, exercise of defence of legal claims. And the Court of Appeal held here that that exception covered all legal proceedings, and therefore a party in legal proceedings cannot object to the processing of his sensitive personal data, even if, as here, the party, the Home Office, is the very party which has deported him and whose decision he is opposing. The second issue related to the arrangement for erasure of personal data. This is more commonly known as the right to be forgotten. And here, the Home Office had arranged that the data would be destroyed by the British High Commission in Kingston, Jamaica, 7 days after its use, and the Court of Appeal found that that was a proper protection of the data. The third issue was an interesting one, which the Court of Appeal did not decide, and that was whether the British High Commission in Jamaica, or indeed anywhere else, actually represented foreign territory. Commissions and embassies are inviolable territories of the country who has them. So, for example, the British High Commission in Jamaica is regarded, for all intents and purposes, as part of the United Kingdom. The Court of Appeal did not have to decide that matter here and left it open. The fourth issue was whether there was impermissible discrimination against the appellant in that citizens of the European Economic Area, which is slightly different from the European Union, have greater rights than non-EEA members, and the Court of Appeal said that that was not impermissible discrimination, but clearly within the European Union there is discrimination against non-European Union or EEA members. And the fifth issue was whether there was an infringement of the appellant's human rights. But again, given the fact that the data was for use in legal proceedings, the Court of Appeal said no, and the fact that the very person using the data, the controller, was his opponent in the legal proceedings was not relevant, and it's up to the court or tribunal to deal with the matter. And in cases such as deportation and immigration cases, it will often be the case that the other party is the one who controls the data. It will often be the case in criminal proceedings. Details of the case and my accompanying written blog are on screen, but it's a useful and helpful case, and it's also comfort to lawyers who I know can become worried about the Data Protection Act 2018.